From the WATE.com Digital Center, answering your legal questions. This is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
Hi, everyone. Glad you're with us today. I'm Lori Tucker, along with our legal analyst, Greg Isaacs, and we are talking about a case that has garnered so much attention for quite a while now, it seems. It seems like it's taken years, and literally it has, to get to trial. We're talking about the Megan Boswell case, the mother who's accused of killing her little girl, Evelyn. And this is a case that takes us back. Evelyn, a toddler that was reported missing, and then it ended up with the mother being charged with her murder.
You know, it does, Lori, a case from Upper East Tennessee, and a very sad case. A toddler went missing, but after the investigation unfolded, the toddler had been missing for about 2.5 months. Actually, from the time Evelyn was reported missing, there was only 17 days elapsed. They found the young child's decayed body upside down in a waste container on her grandfather's farm. But a very tragic and sad case that's unfolding
So sad.
In the courtroom as we speak.
And the first witnesses took the stand today. So let's talk about the fact that the jury was finally seated, and that took a little bit because a lot of people on day one said, hey, I already know about this case. I can't be a juror.
Well, there was some interesting dynamics. This is the first time in that county that a jury has been sequestered in the last 15 to 20 years.
Interesting.
And what does that mean? That means basically that once you are impaneled, you can't go home. You have to give this bailiffs your cell phone, and it's like the real deal.
And the judge said yesterday, be prepared to be sequestered for 2 weeks at least.
At least. And, you know, I wonder if the fact that the lawyers had asked for the jury to be sequestered had made its way out into the community, because I had never seen a judge in the middle of a trial like this issue an order that compelled the sheriff to go physically pick up jurors that failed to appear.
Didn't he threaten them with arrest?
With contempt.
If you don't show up,
I think there were at least 10 jurors because they had trouble filling the panel, and sheriff's deputies apparently went out to compel or persuade those jurors to do their civic duty. But you know, what an unfortunate and sad development if you're the lawyer. I mean, you have a juror that one did not want to be there and has been compelled by law enforcement to show up. Basically,
it's
you know,
tough.
a juror that I wouldn't want on my case.
Right. Are you surprised that this stayed in Sullivan County?
You know, I am, and you know, when we look at the bases under Tennessee law to move a case because of publicity, when you ask for a change of venue, the modern take on a change of venue is you, instead of moving the trial or the circus out of town, you basically get a different vernier from another county that's transported in. Which sounds very cumbersome, but in cases that I've been involved with, Kenny Bartley up in Campbell County, Thomas Husky, the zoo man, you know, it worked fairly seamlessly. But you know, that really adds fuel to the fire when you're a juror and you're sitting there getting your $11 a day per diem or whatever it is these days, and you're sequestered, not only sequestered, but you're placed in a bus and transported across the state of Tennessee. But that didn't happen here. In spite of all this inflammatory publicity, and you know, Lori, just the backdrop that these jurors heard during opening statements. You know, the mother, Megan Boswell, 18 years old at the time, told, and the prosecution outlined this beautifully, story after story, lie after lie, and basically said that the child was given to the biological father for a period of time. Basically, the child had been given to somebody that would be a better caretaker than she would be.
Then claimed the child's grandfather had the child for a while.
Yeah, and all the while, she has a new boyfriend and is traveling to Pigeon Forge, to Gatlinburg, and then moves in. But you know, it's eerily similar. And then the decaying body is found 17 days after the official report that the child was missing. But it's really very similar to the Casey Anthony case.
It reminds me of
And
that. There's little Evelyn right there. Precious little girl, 15 months old.
Very callous, non-caring individual. And this obviously is a serious case. It's one of those where you scratch your head. The prosecution did not ask for the death penalty, but they have filed a notice and are seeking life without parole. So if there is a conviction, there'll be a bifurcated trial on the issue of whether the sentence would be life without parole, but a 19-count indictment that begins with first-degree murder, felony murder, aggravated child abuse and neglect, abuse of a corpse.
When you think of that little girl's body where it was for quite a while, when the mother was saying, "Oh, she's missing. I don't know where she is." And well, speaking of the mom and the jury and the judge's instructions, talk about when the judge says, "Okay, the mother, the defendant, may or may not be interviewed. They may or may not be asked to give their testimony. Don't use that against her if she doesn't testify." What that was said today.
Well, in every case, and that's one thing that you really want to touch on, and I think the judge did in his voir dire, and that's a French term for speak freely, and basically the judge asks the jurors questions, then the lawyers get a chance, and what you're trying to do is determine if they're going to be fair and impartial. But the game within the game is you want a juror that's going to be favorable. So you ask them a lot of questions. But in terms of your point, and it's a very difficult subject to broach, but under our Constitution, you can never be compelled under the Fifth Amendment to incriminate yourself, take the witness stand, and the jury cannot use that against you. They cannot create your failure to testify on your own behalf as an inference of guilt or
Which is why
negativity.
typically you don't want these defendants on the stand, usually.
Well, there's schools of thoughts, and I've had cases, and typically it's a judgment call. And if you feel the state hasn't proven their case beyond a reasonable doubt, then you don't want to risk putting your client on the stand and subjecting someone to very vigorous cross-examination, and especially a young mother as Boswell is in this case, with horrific facts. So, she would be just pounded with question after question that she can't answer and asked to explain story after story, fabrication after fabrication. And, you really don't want your client subjected to that legal buzzsaw.
In the meantime, though, the jury is being subjected to photographs of horribly disturbing images of what happened to that little girl.
And let me tell you how, and this is what you really can lose control quick if you're a defense lawyer in a case like this. Jurors have already started crying and weeping during the state's opening statement.
It's a tough case.
You've got your hands cut out with you. But it was interesting as I just saw the footage of her walking back in jail clothes. In a lot of cases like this, when you talk about pretrial publicity, inflammatory publicity, you don't like images of your client dressed in jail attire.
Yeah.
And I'm
looking
just curious,
down, hiding her face with her hair.
Well, you want to be able to dress out and create a picture of normalcy to the jury when you're trying to persuade them to rule on your client's behalf. But this is a very difficult case, very horrific facts. But it's interesting when I was commenting on the Casey Anthony case, the same thing. While that child was missing, just a little bit older, a toddler, Casey Anthony was a quote party girl that went out and just was very cavalier, had very similar stories, and basically the defense pounded on reasonable doubt. There was no proof of death, whether it was accidental or caused at the hands of the mother. So here's what you're going to see the battle of this case. So one, you're just going to have to very delicately accept and embrace that these are bad facts, and it's going to be emotionally draining to everybody in that courtroom. But what you've got to focus on is the cause of death. You've got to really zone in on the postmortem interval, when it happened, how it happened, and make the state prove that your client committed the homicide,
was there at the time of death,
and prove how they did it.
Yeah.
So if you are the state, one thing you have, you have all the emotion on your side. You've got the inconsistent statements, but on the other hand, you've got to prove that she committed this murder.
So what
And
are you saying? I mean, if it was
I'm
on the
saying,
grandfather's property,
well,
are they?
if it's
Can
on
they
the
bring up
grandfather's
other
property,
people?
and it's, they've already started to float that kind of theory out.
Mhm.
How did he suddenly have the epiphany that, oops, I think she maybe, did you look over there? So, what really in this case, if you put the publicity aside, is what the lawyers are going to ask, and ask you as a juror to make a judgment on the facts and the law. I want to hone in on what that medical examiner has to say, the forensics,
Yeah.
and I want to know when this little girl died and how this little girl died, and how you're going to tie that in beyond a reasonable doubt to Megan Boswell. So you know what? The best friend of those defense lawyers in that courtroom is not their client. It's the burden of proof, and it's a very high standard under our system of justice.
All right. Let's talk more at 5:30.
Let's do.
Thank you for joining us.